You are standing in a courtroom that no longer exists. The air is thick with coal smoke and winter cold. It is London, sometime in the 1780s, and the room smells of wet wool and tallow candles. The jury box is filled with merchants and landowners, men who were pulled from their shops and homes this morning and told they must decide whether another man lives or dies. The judge has just finished his instructions. He has told them what the law requires. He has told them about the evidence, but he has not told them how certain they must be, because no one has found the words yet. The defendant stands in the dock, hands gripping the rail. He has been accused of theft, of taking a bolt of cloth from a merchant's stall. The penalty, if he is convicted, is death. The jurors shift in their seats. They have heard the witnesses, they have seen the cloth, but something nags at them. A neighbor swears the man was elsewhere. The merchant's apprentice hesitated when asked to identify him. The light that day was poor. How sure must they be? The judge has used phrases like satisfied in conscience and morally certain, but these words feel like sand. They slip through the fingers. One juror believes moral certainty means near absolute conviction. Another thinks it means something less, a strong suspicion perhaps, or a balance tipped just enough. The man in the dock will hang or walk free depending on which interpretation wins. This is the world before reasonable doubt. You are standing now in a different room, decades later. It is 1798, and you are inside the Old Bailey, the Central Criminal Court of London. The room is larger now, the gallery crowded with spectators who have come to watch justice, or theater, depending on how you see it. Barristers wear their powdered wigs. The accused sits below, pale and silent. The case is a forgery. A man is accused of altering a promissory note, a crime that carries the death penalty. The evidence is circumstantial, handwriting that might match, a motive that makes sense, but no witness who saw him do it. The defense barrister rises. He is young, ambitious, and he has been thinking about this problem, the problem of certainty, for weeks. He addresses the jury carefully. You must be satisfied, he says, beyond reasonable doubt. The phrase hangs in the air. It is not the first time these words have been spoken. Legal scholars have traced earlier uses scattered through trial transcripts and judges' notes, whispered in corridors and written in margins. But this moment, this public utterance in a capital case, begins to give the phrase weight. The jury listens. Reasonable doubt, not absolute certainty, which is impossible in human affairs, not mere suspicion, which would let the guilty walk free, but something in between, a doubt that a reasonable person would entertain, a doubt based not on fantasy or fear, but on the evidence itself or the lack of it. The jurors acquit, and slowly, case by case, year by year, the phrase begins to spread. You are standing in Boston now, in the spring of 1850. The courtroom is American, but it carries the weight of English tradition. The walls are paneled in dark wood. Sunlight filters through tall windows. The gallery is packed, standing room only, because this is the trial everyone is talking about. The defendant's name is John White Webster. He is a professor, a Harvard professor no less, a man of science and reputation. He is accused of murdering Dr. George Parkman, a wealthy physician and benefactor, and dismembering his body in the laboratory beneath the medical college. The evidence is grotesque. Human remains were found in the laboratory's furnace, in a tea chest, in a vault beneath the privy. A janitor named Ephraim Littlefield discovered them after growing suspicious of Professor Webster's behavior. The remains were charred, incomplete, but experts have testified they belonged to Dr. Parkman. A set of dentures, custom-made, was recovered from the ashes, and Dr. Parkman's dentist has identified them. But there is no witness to the killing. No one saw Webster strike the blow. No one heard a struggle. The case is built entirely on circumstantial evidence, on fragments and inferences, on behavior and opportunity. You watch as the defense attorney, Pliny Merrick, rises to give his closing argument. He is a skilled orator, and he knows the stakes. If Webster is convicted, he will hang. Merrick's task is to plant doubt, to make the jurors question whether the remains are truly Parkman's, whether the death was truly murder, whether Webster was truly the one responsible. But the prosecution has been thorough. The Attorney General, John Clifford, has built his case brick by brick. He has called the dentist, the chemists, the anatomists. He has walked the jury through the timeline. He has shown that Webster owed Parkman money, that Parkman came to the college on the day he disappeared, that Webster lied about seeing him. Now Chief Justice Lemuel Shaw must instruct the jury. You watch him closely. Shaw is one of the most respected jurists in America, a man whose opinions shape the common law. He is elderly now, his face lined, his voice deliberate. He leans forward slightly, and the courtroom falls silent. You must be satisfied of the defendant's guilt, Shaw says, beyond a reasonable doubt. He pauses. But what is reasonable doubt? The question hangs in the air, and Shaw begins to answer it, not with a simple definition, but with a careful explanation, one that will be quoted in law books for more than a century. It is not a mere possible doubt, Shaw says, because everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. You watch the jurors as they listen. Shaw is trying to give them a standard, a line to mark the boundary between guilt and innocence. The doubt must be reasonable, grounded in the evidence. It must be the kind of doubt that would make a reasonable person hesitate to act in a matter of importance in their own affairs. But it is not certainty. Shaw is clear about this. Absolute certainty cannot be attained in human affairs, he tells them. The law does not demand the impossible. The jury retires. They deliberate for 3 hours. When they return, the foreman stands and delivers the verdict. Guilty. Professor John White Webster is sentenced to hang. But Shaw's instruction survives. His words, beyond a reasonable doubt, become the standard. They are copied into other jury instructions, cited in other cases, carried westward as the country grows. Shaw has done what the law needed. He has given definition to a phrase that was, until now, more feeling than fact. And yet, as you stand in that courtroom, you might wonder whether the jury truly understood. Because Shaw also told them they must have an abiding conviction to a moral certainty. And those words, moral certainty, carry the weight of the old language, the language that came before reasonable doubt. They suggest something close to absolute belief, something that might be too high a bar, or not high enough, depending on who is listening. This tension between doubt and certainty, between reason and morality, will haunt the phrase for more than a century. You are standing in a different courtroom now, a century and 20 years later. It is 1970, and you are in New York, in a family court in the borough of the Bronx. The room is smaller than the grand courtrooms of the past. The gallery is nearly empty. This is not a murder trial. This is a juvenile delinquency proceeding, a case involving a 12-year-old boy named Samuel Winship. Samuel has been accused of stealing $112 from a woman's purse. The incident occurred in a locker at a Coney Island club. A witness saw Samuel running from the area. The money was never recovered. In an adult criminal trial, the state would have to prove Samuel's guilt beyond a reasonable doubt. But this is family court, and the standard here is different. The judge need only find that the evidence establishes guilt by a preponderance of the evidence, meaning it is more likely than not that Samuel committed the theft. It is the same standard used in civil cases, in lawsuits over contracts or car accidents. The judge finds Samuel delinquent. He is sent to a training school for an initial period of 18 months, with the possibility of an extension until his 18th birthday. Samuel's attorney appeals. He argues that the lower standard of proof violates Samuel's rights under the Due Process Clause of the 14th Amendment. He argues that when the state accuses someone of a crime, even a child, it must prove guilt beyond a reasonable doubt. The case rises through the courts, and eventually it reaches the United States Supreme Court. You are standing in the courtroom in Washington, D.C., in March 1970, when the case is argued. The justices sit along the bench, their faces thoughtful. This is not a sensational case. There are no charred remains, no Harvard professors. But the legal question is profound. Does the Constitution require proof beyond a reasonable doubt in every criminal case? The answer, surprisingly, is not settled. For all the centuries of English common law, for all the American cases that have invoked the phrase, the Supreme Court has never explicitly held that the Constitution demands this standard. It has been assumed, practiced, repeated, but never constitutionally enshrined. Justice William Brennan writes the opinion. You can feel the weight of it as the decision is announced. Brennan is known for his expansive view of individual rights, and here he is careful, methodical. He begins by acknowledging the history. The reasonable doubt standard, he writes, has been required in criminal cases in federal courts since the beginning of our national history. But is it just tradition, or is it constitutional? Brennan says it is both. The accused, during a criminal prosecution, has at stake interests of immense importance, both because of the possibility that he may lose his liberty upon conviction, and because of the certainty that he would be stigmatized by the conviction. He continues, due process requires that the prosecution prove beyond a reasonable doubt every fact necessary to constitute the crime charged. The words are simple, but their implications are vast. Brennan is saying that reasonable doubt is not merely a common law tradition. It is a constitutional requirement, rooted in the Due Process Clause. Without it, the state could take a person's liberty on the basis of mere probability, a coin flip, more or less. The preponderance standard used in Samuel Winship's case is struck down. The conviction is reversed, and from this moment forward, every criminal trial in America, every prosecution for every crime, from petty theft to capital murder, must meet the standard of proof beyond a reasonable doubt. You watch as the decision is published, as it is read in law schools, as it filters down into every courtroom in every state. This is the moment when reasonable doubt becomes more than a phrase. It becomes a constitutional promise. But you are still standing in a courtroom, and you begin to notice something troubling. It is a few years after Winship, and judges across the country are giving jury instructions. They are trying to explain reasonable doubt to ordinary citizens, to teachers, mechanics, retirees, people who did not go to law school and who are now being asked to decide the fate of another human being. And the instructions are wildly inconsistent. In one courtroom, the judge tells the jury that reasonable doubt is a doubt based on reason and common sense. In another, the judge says it is the kind of doubt that would make a reasonable person hesitate to act. In yet another, the judge uses Chief Justice Shaw's old language, an abiding conviction to a moral certainty. Some judges try to be helpful. They offer metaphors. They say reasonable doubt is like a substantial doubt or a serious doubt. They say it is more than a mere possible doubt, but less than absolute certainty. But these attempts often backfire, because when you start attaching adjectives to doubt, when you say it must be substantial or serious, you risk making jurors think the standard is higher than it is. And when you invoke moral certainty, you risk confusing them entirely, because what does moral certainty even mean? Is it a gut feeling? A religious conviction? A logical conclusion? The confusion reaches the Supreme Court again in 1994 in a case called Victor v. Nebraska. The defendant, Sandoval Victor, was convicted of murder in California. At his trial, the judge instructed the jury using an old formula that included the phrase moral certainty. Victor's attorney argued on appeal that this language was unconstitutionally vague, that it diluted the reasonable doubt standard and made it easier for the state to convict. The Supreme Court disagrees. In an opinion by Justice Sandra Day O'Connor, the court holds that the instruction, taken as a whole, was acceptable. But O'Connor also issues a warning. She notes that the phrase moral certainty is confusing and outdated, and she suggests that courts stop using it. The beyond a reasonable doubt standard, O'Connor writes, is a basic protection rooted in the common law that requires the government to meet a high standard of proof in criminal cases. But she does not say exactly how high, and this is the problem. Reasonable doubt is the most important standard in criminal law, the threshold that determines whether a person is convicted or acquitted, and yet no one can quite agree on what it means. You begin to see the consequences. You are standing in a courtroom in Los Angeles now. It is October 1995. The defendant is O.J. Simpson, and the case has consumed the nation. The trial has lasted months. The evidence is overwhelming in some ways. Simpson's blood at the crime scene, the victim's blood in his car, a glove that appears to match, a history of domestic violence. But the defense has attacked the investigation, suggesting evidence was planted, mishandled, contaminated. They have pointed to a racist detective, sloppy lab work, a rushed case. The jury has been deliberating for less than 4 hours when they return with a verdict: not guilty. You watch the reaction ripple through the courtroom, through the country. Some believe justice was done. Others believe the jury misunderstood their role. Legal analysts debate whether the jurors applied the reasonable doubt standard correctly, whether they acquitted because they genuinely doubted Simpson's guilt, or because they doubted the integrity of the police and the prosecution. But here is the deeper question: what were the jurors supposed to do with their doubt? And in criminal law, not guilty has never meant innocent. It means the evidence did not reach the threshold the Constitution demands. A jury does not declare a person innocent. It simply decides whether the state has proved guilt. And if reasonable doubt remains, the law requires an acquittal, even if the jurors still wonder what truly happened. If they believed the defense's theory that evidence was planted, then they had reasonable doubt, and they were required to acquit. But what if they thought the defense's theory was unlikely, but possible? What if they thought Simpson probably did it, but the investigation was flawed enough to create uncertainty? Reasonable doubt does not mean no doubt. It does not mean the defendant is innocent. It means the evidence does not convince you, to the degree required by law, that the defendant is guilty. But how convinced is convinced enough? The jurors in the Simpson case were not given a percentage. They were not told, "You must be 90% sure or 95% sure." They were told only that they must be convinced beyond a reasonable doubt. And in the end, they said they were not. You stand in the empty courtroom after the verdict, and you realize that this is what reasonable doubt looks like in practice. It is not a formula. It is not a bright line. It is a standard that depends on the judgment of 12 ordinary people, each of whom brings their own experiences, their own biases, their own sense of what is reasonable. And sometimes, those 12 people will disagree with the rest of the country. You are standing in a law library now, late at night. The shelves are filled with casebooks and treatises, and you pull down a volume on criminal procedure. You want to understand what scholars say about reasonable doubt, what the experts think it means. You find an article by a professor who has studied jury instructions. He has collected hundreds of them from courts across the country, and he has found that some jurisdictions define reasonable doubt in fewer than 50 words, while others use more than 300. Some avoid defining it at all, simply telling jurors that the phrase means what it says. You find another article, this one by a psychologist who studies decision-making. She has run experiments in which mock jurors are given different definitions of reasonable doubt and then asked to decide hypothetical cases. The results are striking. Depending on the instruction, conviction rates vary by as much as 20%. This means that the words judges choose, words that are supposed to clarify the standard, actually change outcomes. They make convictions more or less likely, not because the evidence is different, but because the instruction is different. You begin to see the problem in a new light. Reasonable doubt is supposed to be a protection. It is supposed to ensure that the state cannot take your liberty unless it proves its case convincingly, unless it satisfies the jury not just that you might be guilty, but that you are guilty, based on reason and evidence. But if jurors do not understand the instruction, if they think reasonable doubt means no doubt at all, or if they think it means a hunch that something is off, then the protection collapses. And there is another problem, one that is even harder to solve. Reasonable doubt is not just a cognitive standard, it is an emotional one. When you sit on a jury, you are not a computer processing data. You are a human being, listening to witnesses, watching the defendant, imagining what happened. You bring your own life to the jury box, your own experiences with violence or dishonesty, your own trust or distrust of authority. And sometimes, the doubt you feel is not reasonable. It is personal. Maybe you doubt the police officer because you were once treated unfairly by the police. Maybe you doubt the defendant because they remind you of someone who hurt you. Maybe you cling to doubt because the idea of sending someone to prison terrifies you. Or maybe you dismiss doubt because you believe the defendant is the kind of person who would do this, regardless of the evidence. Reasonable doubt is supposed to guard against these distortions. It is supposed to force you to focus on the evidence, to set aside your feelings and prejudices, and decide the case based on reason. But how do you know if your doubt is reasonable or not? You are standing in a courtroom one last time. It is present day, and you are watching a judge instruct a jury. The trial has just concluded. The defendant is accused of assault. The evidence was conflicting. One witness said the defendant threw the first punch. Another said he was defending himself. There is a video, but it is blurry and taken from a distance. The jury has been listening for 3 days. The judge begins the instruction. In order to convict the defendant, the judge says, the government must prove guilt beyond a reasonable doubt. This does not mean beyond all doubt, or beyond a shadow of a doubt. It means a doubt based on reason and common sense, arising from the evidence or the lack of evidence. The judge pauses. If, after carefully considering all the evidence, you are firmly convinced that the defendant is guilty, then you should find him guilty. But if you are not firmly convinced, if you have a reasonable doubt, then you must find him not guilty. The jury nods. They file out to deliberate, and you are left standing in the quiet courtroom, thinking about what just happened. The judge gave a clear instruction. It was simple, concise, and it tracked the language approved by appellate courts. But did the jurors understand it? Do they know what it means to be firmly convinced? Do they know the difference between a reasonable doubt and an unreasonable one? And even if they understand the words, will they apply them fairly? Because here is the truth about reasonable doubt. It is not self-executing. It is not a machine that produces the same result every time. It is a standard that depends on human judgment, and human judgment is messy, inconsistent, and deeply personal. Two juries, hearing the same evidence, can reach opposite conclusions. One jury might convict because they believe the witness. Another might acquit because they think the video raises doubt. Both juries will believe they followed the law. Both will believe they applied the reasonable doubt standard correctly. And in a sense, they are both right. Because reasonable doubt is not a fact. It is a feeling that must be grounded in reason, but a feeling nonetheless. It is the feeling that the state has not done enough, that the evidence does not convince, that something is missing or uncertain or wrong. And when 12 people share that feeling, the defendant goes free. You are standing outside the courthouse now, on the steps in the late afternoon light. You think about all the courtrooms you have visited, all the trials you have witnessed, all the juries you have watched. You think about Chief Justice Shaw in 1850, trying to explain reasonable doubt to a jury that would decide whether a Harvard professor would hang. You think about Justice Brennan in 1970, writing that reasonable doubt is a constitutional right, a promise that the state cannot take your freedom lightly. You think about the O.J. Simpson jury, deliberating for less than 4 hours and returning a verdict that shocked the world. And you think about the defendant in today's trial, waiting in a holding cell while 12 strangers decide his fate. This is the system we have built. It is not perfect. It is not even fully comprehensible. But it is rooted in a principle that is worth preserving. The state must prove its case, not to a certainty, but to a standard that a reasonable person would accept. Reasonable doubt is the line we have drawn between freedom and punishment, between innocence and guilt. It is a line drawn in language, in the shifting meanings of words, in the judgments of ordinary people who are asked to do something extraordinary. You watch the sun dip lower, casting long shadows across the courthouse steps, and you realize that reasonable doubt is not just a legal standard. It is an acknowledgement of the limits of human knowledge. It is a recognition that we can never be absolutely certain about the past, about what someone did or did not do, about what happened in a moment we did not witness. All we can do is look at the evidence, think carefully, and decide whether we are convinced. And if we are not convinced, if doubt remains, the kind of doubt a reasonable person would have, then we must let the accused go free. This is the promise of reasonable doubt. It is the reason the phrase was born, the reason it was tested and refined over centuries, the reason it was written into the Constitution. It is a protection against the power of the state, and it is a burden placed on the shoulders of every jury, in every trial, in every courtroom where justice is sought. You turn and walk down the courthouse steps, and the words echo in your mind, beyond a reasonable doubt. Not beyond all doubt, just reasonable doubt. And you wonder, as generations of jurors have wondered before you, whether you would know it if you felt it.